Now you are.
Yeah, it said stop, so that was strange.
Okay, it's recording now.
Art, that looks like a glamour shot.
It was a bigger picture before. I genuinely thought he was just being very still.
I could just have a crappy camera too, making a very small picture.
Where is everybody?
We don't have anybody in the room?
We have one person that I let in.
Getting a lot of text messages that people are trying to get in. I got somebody telling me unable to join the meeting. I told them to log out and log back in.
There was one person and they are on the meeting. Okay, try again.
Hey, Brooke, my
There we
wife
go.
just said that she tried to join. It says host locked.
It said
Oh,
unlocked, but I'm now getting a bunch, so here we go.
Oh, so okay. There we go. I started getting worried.
Me too.
Yeah, I look just like Christian.
Doppelganger. I have nobody waiting in the waiting room at the moment.
Would you like to start?
That is up to you, or we can wait, give it maybe a few more minutes. I just got one, but not a whole bunch.
Just sit out in the hall and listen.
Okay.
You can sit right here.
As long as I'm off camera.
I'll show you.
Okay. Yeah.
You can log out and log back in, and if it gets fixed, then you can leave.
All right. As of right now, I have nobody waiting in the waiting room. We have 45 participants.
It's a record.
So if we would like to start, go ahead, Art.
Okay. Welcome, ladies and gentlemen. I'm Arthur May. I'm the president of the HOA governing board. I was elected, I believe, a year ago, and have been serving in that capacity. I'd like to introduce the rest of the board based on how they show up on my screen. I've got Darius Mystery. He's a homeowner who's been on the board now for about 9 years. Next to him, I have Kevin. He has been on the board for 6 years. Then I have, you just jumped, Raman. I've got Raman Daha. He has been on the board for about 8 years and is a past president of the board. Also, Kevin was a past president of the board also. We have Todd Millsap, who is our newest member of the board, has been on for about 4 years now. We also have Brooke and Harmon from Focus HOA Management. Many of you have probably spoken to them on various issues over the years. And we also have Jonathan Eberhauser, who is the HOA attorney, who's here to answer questions about the proposal to amend the CC&Rs. This evening, we're here to take your comments. Everyone will be muted to begin with. When it's your turn to ask a comment or make a comment or ask a question, then you will be unmuted. Brooke is the one, I believe, who has the switch for that. We ask that you please be polite and ask the questions that are important to you. Each person will have 3 minutes. If somebody, for some reason, decides that they need to be argumentative or make a long statement that doesn't seem to be going anywhere, we reserve the right to mute them. And the next person will be called. I don't think it would be productive for me to go through all of the questions and accusations that have been leveled against the board in the past 3 weeks. Instead, I believe that everybody who has a question or has something that's important to them will ask that question, and then we can address it. That way, we just have to go over the most important things to the people who are actually in the meeting. So with that, I would like to turn the floor over to Jonathan Eberhauser for the rest of the meeting.
Thank you, Art. My name is, Jonathan Eberhauser. I'm an attorney at Carpenter, Hazelwood, Delgado, and Bolin. We've represented your association for several years, and that we are here tonight to talk about walls, specifically wall maintenance as it relates to those lots that share a wall with common area of the association. So what we've been dealing with as a board of directors, or what your board has been dealing with over several years, has been this question of what do we do when there's a dispute regarding wall maintenance between homeowners' lots and common areas? And this question is becoming even more important with aging infrastructure throughout the valley. We're seeing, it's just time for walls to start having problems. And so it's an important question. Historically, what the board has done in cases where there is wall maintenance required between common area and a lot has been that the homeowner and the association share that cost 50-50. And so that's fine and good. The problem is that in doing so and interpreting your CCNRs, we get into really muddy water on how that works. And so what ends up happening is we get in disputes with homeowners, and we're trying to figure out how, people have different interpretations of CCNRs. And so we end up grappling with how do we solve this problem. Historically, as I said, it's been, we share it 50-50. But what the association's trying to do through amendment of the CCNRs is clarify the current interpretation of the CCNRs, the historic interpretation of the CCNRs, kind of take these muddy documents, put them into layman's terms, and express clearly that there should be no confusion for you as homeowners. The wall maintenance is shared 50-50 between the homeowners and the association for those walls that are shared between an association and the homeowner, just as wall maintenance is shared between you and your neighbor 50-50. We want the same rationality to be applied to the homeowners association. We believe the documents currently do that. We just want to make it crystal clear. That preempted and prompted the written consent proposal, trying to clarify those documents. Unfortunately, the documents you have are very technical, and what we tried to do is slide in the language to make that clear. And I think probably what we did in the process is just make it more unfriendly to homeowner layman interpretations of the CCNRs. I can acknowledge that. We're trying to work within the confines of the language. Typically speaking, that's more received. It's better received by homeowners when we do that. That's not the case here. And I completely understand that. That's my fault. I want to make this as layman friendly as possible. Anyone who picks up this document should understand clearly right off the bat what happens when we deal with the walls. So I think tonight's purposes is to hear comments for the board to really take this proposal back. Obviously, the written consent has been withdrawn. We're taking tonight as an opportunity to hear resident comments on how do we want this to look? Are we looking for, do we have membership who interpret the CCNRs? And I'm looking for what we currently interpret the CCNRs to say, because we're not trying to change it. Do we interpret the CCNRs to say that the association should be paying for 100% of the cost of maintenance of walls shared with a lot? Or are we taking the position that the association, as it has historically done, and I believe is the appropriate interpretation, that the walls should be fair 50-50 between the homeowners association and the lot owner? I want to present something to you as homeowners that is easy to understand and eliminates any doubt. The last thing I want to do is continue with a set of CCNRs that are murky, and that we continuously end up in situations where the homeowners association and owners are fighting with one another, trying to figure out, well, what's the interpretation of the day? The only person who benefits from that is me, because the solution to that problem is litigation. And until we go through litigation and get to a judge who rules on the interpretation of the CCNRs, you won't have an answer. And so that's why the amendment is helpful, that we want to make sure it's crystal clear. This is what the association's interpretation is. I want to pull up, I'm going to try to share my screen here with you, the CCNRs who understand what I'm talking about. Okay, board, can we all see the CCNR provision that I've highlighted? Okay. Section 10 of your CCNRs is the provision within the documents that talks about wall maintenance. It's really the only provision that contemplates wall maintenance. The document, as you see, provides that the rights and duties between owners and the association with respect to a wall or fence located between the association, or I'm sorry, between two lots, between two parcels, between a lot and a parcel, is defined as a party wall. And that the maintenance of party walls should be governed by the general rules of law regarding party walls. And then it goes on to tell us what that is. The cost of reasonable repair and maintenance of a party wall shall be shared equally by the owners of the adjoining lots or parcels. So the association has historically read this provision to say, when talking about the rights and duties between the owners and the association, the party wall should be shared equally between the owners of the lots and parcels. What that assumes is that the association in that definition is an owner for sake of interpretation of section 10.1. And that is consistent with the general common law rules of party walls. So you're saying common law where I own property that is adjacent to a neighbor and we're not deed restricted, we don't have CC&Rs. The common law, meaning the court interpretation of party wall disputes, would be that I would share the cost 50-50. It goes on to say, and this is also true with the general rules of common law, that if I cause the problem and I cause damage to the wall, that I should assume the full liability. So that's this section 10.2. An owner by their negligence or willful act, or the act of an agent, occupant, licensee, guest, invitee, or family member that causes the wall to be damaged or exposed to the elements shall bear the whole cost of furnishing the necessary restoration or necessary protection against such elements. And that's where we get into these conversations of, yeah, let's default to if there's just regular wear and tear on a wall, and let's just talk generally about any wall, that the owners of that wall would share the cost 50-50. If I back my truck into the wall, I, as the homeowner that was negligent and caused the damage to the wall, would assume the full cost of replacing the wall. Wouldn't have otherwise fallen but for my negligence. That could also be true for overwatering. You know, you can come up with any number of fact scenarios that create negligence and party wall damage. But when we look at in the current version of Section 10 and the historic implementation of Section 10, it has been that when we're talking about common law, walls shared between common areas and lots, and I keep harping on that because I want you to recognize we're not talking about walls between you and your neighbor. We're not talking about walls that you may share. I mean, some of the golf course properties don't share walls with the common area. They share walls with the golf course. We're talking about walls that are shared between the common areas and a lot. So that's a much smaller percentage of your walls. Then in those scenarios, the association has typically worked with the homeowner to share that cost 50-50. Unless there's been some showing of negligence by the homeowner or by the association, which indicates that one of those parties should assume the full cost pursuant to 10.2. So what we're trying to do is make that very clear. If you look back at the written consent and the proposed amendment, the language in 10.1 and 10.2 are still there. What we tried to do is clarify when we talk about, okay, we've got walls between two lots, walls between two parcels, between a lot and a parcel. We've talked about the rights and duties of the owners in the association. So obviously the association has some right and duty incorporated in section 10.1. Let's make it clear that we've also got this category of lots and common areas. And we grappled with this idea of, well, how does that best work for a homeowner? You know, are we trying to physically hire two separate companies, or how does that work? And so typically what happens just in any homeowners association is the association engages a contractor and then seeks reimbursement from the homeowner. That's a cooperative effort. I mean, obviously when we're talking about shared efforts, both parties work together to decide on bids and kind of even do the bid submission process. Not all homeowners want to go through that, but that's a standard process. So what we're trying to grapple with too is this idea of, let's make it very clear that the association will assume the cost and just ask for reimbursement. And that could be just, hey, we'll just put it on your ledger or something like that so that your 50% is addressed. So what we're trying to do is stop possible lawsuits. Let's address every possible scenario. Let's get it very clear. We can do that in a much more layman's terms. But what I want to hear tonight is, well, what's the perspective? If I've got homeowners on the call tonight saying, we believe that the homeowners association and the documents currently, you disagree with my interpretive section 10.1 and 10.2, that the homeowners association is 100% responsible. Okay, then maybe we want to be talking about an amendment to make that very clear. But if I have homeowners on this call tonight saying, no, I think your interpretation of section 10.1 is right, I also want to make that very clear. I think an amendment is important either way. We don't need to continue battling back and forth. Not to say that there have been significant battles, but you know, we have to be forward looking, that walls are deteriorating just in general around the valley. We're at that age and infrastructure. And so this question is going to become more important. And the only people that benefit from the back and forth dialogue is honestly me, because I'm the one that's going to get paid at the lawsuit stage. And so I don't want to get you there. I'd rather make this crystal clear, understand what the membership wants, and make that possible for you. You know, I want to talk a little bit more about what I mean when I say historical. We've looked at this over the years. When there is a dispute or an issue regarding wall maintenance, it's shared 50-50. We also look to the reserve study. The association has never reserved to cover the costs of 100% of the wall replacement for those walls that border common area. And so if the membership is telling me tonight that that's the amendment you're looking for, I just want you to keep in mind that that means we are talking about special assessments and increasing assessments. Right now, the reserve contemplates the current interpretation of section 10.1. If the association is asking to assume the full cost of those repairs, that's fine. It's just a matter of we have to come up with the money from somewhere, and that it will mean special assessments and assessment increases. There's just no way to go around that to make sure you are properly funded. I will open. I think that's kind of my understanding of the CCNRs and what we've proposed so far. I want to open this up to the board for questions first, and then we'll go to the membership and I'll address those as well.
Well, I'd like to make a comment that if we don't get this text clear and it stays muddy, then the board is stuck in the middle where if one homeowner convinces the board to pay 100% and we go to assess another homeowner that doesn't have one of these walls and they don't interpret the rules to say that, then they might take us to court and fight us so that they don't have to pay the assessment. And now we're in court for that. And we want to avoid going to court either way. And the only way to avoid paying attorney costs is to get a clarification on what these rules mean. And we as a board are willing to make them be whatever the majority of homeowners want to vote for. It doesn't matter whether it's 100% or 50%, but whatever it is, it needs to be the majority, and the language needs to clearly state that. And then this board or any other board in the future can maintain that, and there won't be any litigation.
Exactly, Kevin. Yeah, I'm maybe the first to tell you there are arguments. I mean, anytime we're interpreting a contract, there are arguments on either side. That's just true. I'll tell you, I believe my interpretation of the CCNRs is correct. You can disagree with me, that's fine. The problem is that disagreement always ends up in litigation. And so with a homeowners association, you're always stuck between a rock and a hard place, right? If we assume the position that the association pays for 50% of the walls, a homeowner disgruntled by that has to share the cost of the wall brings a claim against the association seeking 100%. If you as a homeowner that doesn't share a wall with the homeowners association is disgruntled by the association's assumption of 100%, you can bring a claim against the association for doing that. And so you can kind of see how when we've got mixed opinions on the interpretation of the CCNRs, the best thing to do is amend it and just make it crystal clear. That's what's trying to occur here. That's what we're opening up for comments on. It's the rock in a hard place. Let's get out of that position. We don't need to be there. Where do you want to be? And we'll go from there.
Thank you.
Hey, Jonathan, can I make one comment?
Please.
I just wanted to say, you brought up if the homeowners feel that the homeowners association should be 100% liable for, you know, the party walls. I think what that boils down to is that the 785 homeowners in here, the majority would pay for the minority's walls, the small portion of people that have those walls. And I think most people would say, I don't want to pay for my neighbor's wall that's over there. And, you know, if they border a common area, I wouldn't want to pay for that. So I think you know,
Sure.
the point is, does everybody agree that we want to pay for other people's walls and share the responsibility?
Yeah, I mean, the reality is, if you are going to increase your reserve contribution, it requires more contribution from you as homeowners. That the only funding mechanism for a homeowners association is the assessment. And so, you know, what the board has historically been saving for is not 100% repair and replacement of the walls. It has been 50-50. Do you have any other board comments or questions? Great. If you've got a resident comment, just click the raise your hand and Brooke will unmute you in kind of order. I see Bill raising his hand.
Yes.
Can you unmute Bill?
And we have Brian first. If you are on a cell phone and you call in, if you press *9, it will show that you raised your hand. So I will ask Brian to unmute, and then you can go ahead.
No, thanks, Brian. I didn't see your hand up there. Perfect.
Hey, good evening, everybody. First, thank you to the board for serving. It's a thankless job and you're between a rock and hard place all the time. A couple of comments and a couple of questions. I believe that the way it's written now is in layman terms. I don't believe there's a lot of legalese. I've hired and worked with many lawyers and had them on my staff in the past. So I don't think it's not in layman's terms. Now, that said, I agree that it should be resolved one way or the other, whatever it is. I'm not sure where I feel about it, but I have questions that are specific to this.
Great.
One is whomever on the board can answer. There's a letter circulating around that says we've spent $400,000 on legal fees. I'd like to know how much we've spent. And I also believe the letter stated we lost that case. So that's question one. Question two, why are we retreating on the amendment now versus having a vote? Was this to clarify it? Finally, beyond the amount of money we've spent, in my opinion, is beyond the ridiculous. Be honest with you, this should have been called long before. I'm not scolding anybody. Should have been called long before if you guys needed approval from the association to amend the HOA. What is the current precedent? How many people have had walls break or have to be paid for, and who's paid in the past? This association is whatever, 28 years old, right? So I'd like to know those things. How much money have we spent paying guys, nice young men like this guy, to interpret that conversation for us? Two, what is the precedent? And why did you retract the first part? So however you want to do it, I'm mainly interested why we spent $400,000 if that is even close to the truth. Okay. And why this wasn't addressed long before that. That's the thing that I think is most bothersome to me, because I respectfully, our lawyer there, you represent all of us here. I know respectfully, for us to be spending $400,000 to interpret 2 paragraphs is honestly beyond the pale. So my 3 minutes is probably up. How much have we spent? What's the precedent? What have we done in the past? And if that's the case, we probably lost the lawsuit if that's true because of that. And I think those are the main things. And why do we retract the amendment? Thank you for listening.
Yeah, Brian, I'm happy to address those. The attorney fees are fairly transparent. That's a line item on your financials. And so you could certainly get with Brooke to get a copy of that. I can't speak off the top of my head of how much you've spent in attorney fees, but it's certainly not $400,000. That would be great for me, but it's not realistic. It's certainly not anywhere near that. But that's, I don't have that number, but it is in your budget and it's on your financials. And so that's something that would be pretty easy to see. The association did not lose any lawsuits related to wall maintenance. The only lawsuit that was raised on this issue was dismissed. That means neither party. That's just dismissed. What was your other question? Why did we retract?
And precedents.
And the precedent. The precedent here has been, yeah, there have been several homes over the last few years that have experienced some level of wall maintenance. The association generally shares the cost 50-50. You've got those outlier scenarios, as I outlined, that you could have damage caused by homeowners that would change the nature of repairs, but historically it's been 50-50. The written consent was withdrawn because we were receiving, I had asked for the membership comments to be forwarded to me so that I could see kind of what was going on, and then we could have a meeting like this to address those questions. The vast majority of those comments were not related to the intent, this idea that we're reaffirming section 10.1's 50-50 obligation to share the cost with the association and the homeowner. They were based on the interpretation and the understanding of the actual language. So I tend to agree with you, Brian, that 10.1 is very clear to me that it's a 50-50 contribution. Unfortunately, not everyone does agree, and those disagreements will end up in litigation until we get a judge to actually tell us how to interpret those CC&Rs. So it was withdrawn because the goal here is to make this easy to use. We draft these things, the developers draft these things, especially when they're drafted, 20 years ago, 30 years ago. They're not drafted the way that we want them to be drafted today. We've gotten better at this over time, and we can put this in layman terms. Yeah. So that was the goal, is that let's have this meeting, let's hear the comments, let's make sure our understanding is correct. If our understanding is correct, that people are looking to just reaffirm 10.1, then yeah, then the amendment would be, let's just put this thing really crystal clear. Here's what happens if you're between a lot and a common area. Here's what happens between two lots. It's shared 50-50. And we just make it very that blunt, That's the thought process. Did that answer all the questions? I think I checked them. Perfect.
Okay. I'm going to ask Bill to unmute.
Thank you. Okay, the question I have basically is in two parts, one of which is maintenance. Primarily, this is addressed to focus. How often do you go around throughout our association looking at walls, looking at potential hazards, looking at potential, lack of a better word, threats that would threaten the HOA for us all to have to now cover the cost of major repairs when basic maintenance is the key word that should have been done on potential walls. Next goes to the next is parcel 7, which borders on the western side of Greenfield, where we have the canal and the western so-called wall. From my recollection, when I'm original homeowner, when the whole association was being built, and I was a member of the board on the conception, there was a flood barrier wall that was constructed on the western side. Now, apparently I wasn't paying attention because I don't live up in that area, that either the investors, original realtors, I do not know, they built the wall on top of that barrier. Not a wall, but on top of a barrier wall. So I do not know if that wall was drilled into the barrier wall to hold it for retention. But now you have a 3-foot level elevation difference. And now that soil and erosion is now pushing on that wall for the last so-called 20 plus years. Where has Focus and the board been going around to our HOA and inspecting these potential hazards? So to me, I can see that the HOA plays a big majority of the responsibility, other with the homeowner, in regards to saying, hey, my wall's bending out. What's going to happen further down the line? So I am on board with your ruling that it is a party wall, but is it a party wall? Is it a perimeter wall? What wall is it? That's my question or questions. Thank you.
And Bill, I'll start off with talking about this perimeter wall question. So I've seen that word come up in the comments. Let me pull that section of the CCNRs. I'm going to share my screen again here. The idea of does everyone see, you see that section 6.5?
Yep.
Yes.
Okay. The only reference to perimeter wall is made in section 6.5 of the CCNRs when it's granting easements to the homeowners and the association. And it says that there's hereby created an easement over and across each lot and parcel that's adjacent to the perimeter boundaries of the project, a street, or a common area for reasonable ingress, egress, installation, replacement, maintenance, and repair of a project perimeter wall located on the easement. That easement is in favor of the association and those owners and parcels who are subject to the easement. And so I've heard comments. I think this is where this idea of who maintains perimeter walls is coming from. To me, section 6.5 tells us nothing about who maintains the perimeter walls. It gives the association and the owners an equal easement interest to cause repairs to a perimeter wall. That's not a defined term like a party wall is. It's not a capital P perimeter wall. So I don't know what a perimeter wall is. But to the extent that a perimeter wall exists, both the association and the owners share an equal easement in it. So that provision itself doesn't sway my opinion regarding section 10.1, that those walls between common areas and the lots should be shared equally between the association and the owners. But I think that's where that question's coming from. With regard to the canal and that you're referencing, I'm not sure if that is a wall that's shared with a lot. That's something we would have to look into. I'll turn that over to Brooke to see if she can comment on kind of how those maintenance inspections go and how the association addresses concerns when they're raised. But generally speaking, concerns are raised from landscapers, or concerns are raised by homeowners, walkers. I mean, anytime there's complaint-driven inspections, but also Brooke can speak to the routine inspections as well.
Harmon's actually going to answer that.
Yeah, I'm
Okay.
going to answer that. Jonathan, you want to unshare your screen?
Oh, thank you.
Sure. Yeah, I'd be glad to answer that. And Bill, I think you've been attending quite a few of the board meetings over the last couple of years. So the maintenance of the walls has been a topic on the open board agenda for at least the last 2 to 3 years. The board did have a wall study done by an engineering company that prioritized the walls that need to be addressed and repaired. The board in the last 6 months has hired a consultant to go and start the project management of starting to do those wall repairs. So this is there's an active project you see in the budget for 23 and for 24. In the reserve budget, there's a very large amount of money, over $400,000 that has been set aside in the reserve for wall repair in this project. So we have an engineering study. The board has hired a consultant and a project manager to go forward. So I believe the board, with Jonathan's counsel, said, before we start this major project, let's define or clarify some of the questions around the CCNR so we can start this major repair project. And focuses on site once a week at least, driving the community and looking at things. Hope that answers your question.
Thanks, Harmon. Next person on my screen, Brooke, is Susan, but if you saw someone up first, let me know.
I will go ahead and ask Susan to unmute.
All right, there we go. My name is Susan Cuter. I live on Sagebrush Street, which is a 7-house cul-de-sac. Been here for since 89. No, 98. Sorry, wrong number. That was when I got married. 98. So I was one of the OGs in this neighborhood. And I will just add right now, as a personal aside, that I think our neighborhood looks the best it's looked in the last 15 years. I think our landscaping company is doing an amazing job, and it's unmatched in how it looks compared to previous years and previous landscape companies. So thank you very much for that. I am a teacher, and I tell my students all the time that words mean things. I tell my husband the same thing. He rolls his eyes. So don't roll your eyes at me, okay? My students are allowed to. I think the biggest thing that we could do, we meaning you guys at Focus, is to clarify these words in very definitive third grade level terms. I understand what a party wall is. I think most people do, how it was explained in, I believe it was Art's letter, maybe it was some of the amendments. My neighbor versus my wall and me, we don't share anything other than our wall between our two backyards. But then we start talking about perimeter walls and common area and mutual areas and HOA areas. I think that there are people in this neighborhood right now that do not understand that their wall that's up against Quinn on the north side of our neighborhood is 100% theirs, because that is not a shared wall. It is not a common wall. The 18 inches between that wall and the sidewalk is theirs. They can put purple rocks if they want to. They can let the weeds grow and get a letter from the HOA. They have to pull the weeds. They have to spray the weeds. They have to trim the trees that they've planted there. I think we again, meaning you, need to define those walls. And I've asked, and I was provided with a map, but it was a very rudimentary, probably a 26-year-old map, where, you know, walls that are shared with the golf course and lots are green, and walls that are shared with our neighbors are orange. I mean, something very, like I said, third grade level, where people see on a map color coded or dotted lines versus polka dotted lines. We see what is what, and we can see that there's a wall that is in disrepair. Who owns that wall? Is that 100% the homeowner, or is it 50-50 the golf course and the homeowner, or is it the HOA and the homeowner, or is it two neighbors that are arguing about it? Words mean things, and I think that that is the biggest plus we could make right now, you could make right now, is clarifying those walls, clarifying the property lines, clarifying who owns what. I don't have a common wall. I share with two fabulous neighbors who I love to death. I'm not worried about that. One more thing is, we have a homeowner who is going around telling people that if we do live on cul-de-sacs and there is a hunk of wall at the end where the landscaping company comes and grooms the trees and trims the bushes and sprays for weeds, and that hunk of wall at the end of our cul-de-sac, that if this amendment goes through, we are all going to pay for that wall, or the two adjoining homeowners are going to go pay for that hunk of wall. That there's no way that makes sense. I've read the CCNRs, I read the amendment, I was all in favor of the amendment. Obviously, it's been withdrawn, but that again needs to be clarified. Those pieces of walls at the ends of the cul-de-sacs are the HOAs. If I am wrong, please correct me. But that again, I think words mean things, and we need to be crystal clear. And to our attorney, I respect you, but you need to remember that you're talking to people that need to read at a third grade level.
I completely agree, Susan, and a comment well received. Yeah, and I said this early on. This is a case where we were looking at this as a way of preserving the natural language, and your natural language is just not the way that it needs to be. I mean, that's we look at this and say, yeah, the best option is let's scrap all of section 10 and start over. We can do it better. Let's make it clear. Here's the walls between you and the golf course. Here's the walls between you and your neighbor. Here's the walls between you and the association. Let's just make it that crystal clear. Here's the wall that the association is on, all on common area. Here's the walls that are all on your lot. Those are really your categories. Our interpretation of the CCNRs now would be, yeah, it's 50-50. And so the problem is, as we get that, what I want you just as members to understand is when we get that deep into just rewriting things, that's when people start to think that we're changing something. My goal is not to change the status quo. I want to rewrite it, as Susan suggested, in just third grade words. But it takes that level of kind of chopping this thing out. And, it does. My fear is always, okay, if we do that, there's going to be more disgruntled homeowners that say you somehow misread section 10.1. And so that's where these comments are very helpful. That's where these town halls are very helpful, so that we eliminate that doubt going in. No one's trying to pull the wool over your eyes. We want this to be very transparent in what we're trying to do. And then you as homeowners exercise your right to make it so. Yeah. Thanks, Susan. I appreciate your comments. The next one up is Cody. And Susan, I think you hit it exactly 3 minutes there. It was pretty impressive.
Cody, I will ask you to unmute.
Hey guys, Cody Spencer, how you doing? So I read through this, and I've read through the CCNRs probably 150 times in the last couple of years, and you keep saying common areas, and so the question to me is, what is a common area, right? Is it a parcel, or what is it? So I took it upon myself, went on the Maricopa County Assessor site, looked it up, pulled up the deed, and it lists it as a parcel. So I'm struggling to understand where there is any confusion of how it is not, the walls aren't shared between the association and a homeowner, because it clearly shows a piece of property by the association parcel up against a lot. And to the previous individual's comment, it's just a matter of, I think, simplifying or clarifying. This is a parcel of land owned by the association. It's a shared wall between the association and the homeowner. And how do you do it in a way that simplifies it and doesn't scare people? And so from a legal standpoint, is a common area considered a parcel, or what is it considered, per the assessor? Is it a parcel, a tract? How is it defined? My question,
Sure.
I suppose.
Thanks, Cody. That's a good question. And I want to be very transparent about this. This is the confusing part of your documents. When you look at the deed, the common areas, common area essentially means anything owned by the association. So we've got a deed that tells us the association owns it. When you typically develop a community, the common areas are called tracts. The homeowner dwelling units are called lots. And then you've got public rights of way for the streets. They use the word parcel in the deed, but in defining parcel in the CCNRs, we have a very muddy description of what parcel means. It talks about separate pieces of property in a master development plan split into any matter. And so it almost gives the impression, and the argument has been that it wasn't talking about the common area parcels, it was talking about the bigger parcels that were subdivided into tracts and lots. So I want to be transparent. I disagree with that argument. I think Cody has identified an important argument in favor of my interpretation, but I don't dispute that there is a level of confusion there, that because the CCNRs define parcel differently, that there could be an argument that section 10.1 doesn't relate to a lot between a common area and the association. That's why I point out again, though, then the reference to the association and the owner, that this establishes rights and duties between the homeowners and the association. The words mean something. Why is the association even referenced in section 10.1 if it does not derive a right or duty related to party walls? So they have to have some interest in the party walls. And if we're not referenced as a parcel or a lot, then why are we there? And that's so this argument coming back to the perimeter wall and the parcel description, those are kind of the arguments against my interpretation. I disagree with them, but I'm not going to say that they're not decent arguments. That's why we end up in litigation. I've got Billy as our next hand.
Correct. I'm going to ask Billy to unmute.
Thank you.
I'd just like to make 3 points and you can respond to them.
Sure.
First of all, I wrote to Art about the walls. I have a lot of people in my family that are Masons. And when I moved into this neighborhood 20 years ago, I realized the walls were not really constructed in the best manner. I wrote to Art about it. He told me that a lot of them have insufficient or poor foundations. There's no reinforcing steel, all those kind of issues, which I noticed. But my question is, if the walls were not constructed properly in the beginning, why is the builder not drawn into this? Why does the builder not take some responsibility since they built those walls in the first place? Why do we need to take care of that? I think that they should have a part of responsibility for paying that. The second issue I have is that I'm a little concerned about the choice of contractor. If I want to have someone do something in my home, I decide who the contractor is. If I don't like the arrangement, if I don't like their service, if I don't like the price, I could turn down that service. The way that this is worded, and from my email with Art, I really don't have that option. The board decides, and then I don't want to say stuck, it's not the right exact word, but I am stuck because I have to deal with the contractor that the board chose. The third thing I would like to say is to respond to Todd. I really don't like the concept that the minority of people have party walls. Why should the majority have to pay for the party walls? Going with that kind of theory, I don't really want to pay for the maintenance done in my neighbor's yard. I don't want to pay for the flowers that are 2 streets over. This is a homeowners association, and we act as an association and as a cohesive unit as far as I'm concerned. If we want to revise things and you tell me that, other people don't have to pay for the wall because I happen to have a party wall, well, can I decide not to pay for the water that's used in my neighbor's yard or any of the things that are done a few streets over? Do I have that option as well? Because that's what it sounds like. The few people that have that, that's their responsibility. Why should the other people pay? That is gonna raise an issue of, well, why should I pay for anybody else's maintenance or things if I'm not benefiting from it? So the 3 issues I have are, I think the builder of the walls originally bears some responsibility on their condition. I think that the homeowners should have a say in the contractor and a voice in the end to accept or reject. And I also think that it's not fair that we limit to people who happen to have a party wall. If we do that, then I think that we should open it up that each individual homeowner has a right to say what they feel they should pay for and what they feel they shouldn't pay for. Thank you.
Thank you. Yeah, the builder issue is a great comment. Unfortunately, there's a statute of limitations to bring a claim against your original developer, and it's only 8 years. And so you have a very limited amount of time to discover any deficiencies in the quality of work. And then when we're talking about claims against their contractor's license, it's even shorter, 2 years. So we don't have the ability at this stage to raise any disputes regarding the quality of the original development. I tend to agree with your comment on the contractor. Generally speaking, that's how this works. It's when there's a need for a replacement or repair mutually between the association and the homeowner, they work together to come up with bids and to devise a plan. I know in one situation there was even a homeowner couldn't pay it immediately, and so it was kind of held on the ledger until the lot was sold because it was pending sale anyways. So this isn't a fact of the association isn't trying to work with homeowners to identify contractors and get good bids. That's kind of implied in the process when you've got 2 people that are sharing it. The thing that I have to grapple with as your attorney in writing these kind of changes, that's not contemplated today. It is just in kind of the general common law principle that you would share the maintenance. What we run into, so we could go further and we could say, okay, great, let's add in that we're going to share those costs 50-50. And let's add in that we have to go through this co-bidding process. Problem is we don't always have homeowners that are cooperative. We don't always have homeowners that are responsive. And so what do we do in scenarios where you as a homeowners association are charged with, okay, I'm going to fix the wall because we don't need these kind of walls exposed to the elements. Now we've assumed the debt. You as homeowners have assumed the debt that should be this homeowner's. Yeah, how do we go about fixing it? And then there's this question of, okay, well, you added it to my ledger, but you didn't go through this bidding process. And so it's almost better if we ignore it, to be honest with you, than to try to go through the process, because we'd have to have all of those kind of details included in there. And we certainly can. I think we were trying to do that in the amendment as kind of briefly and concisely as possible. But the language is just muddy. So that's, we're back to the drawing board. And I've got a phone number here ending in 60818. 0818.
Yes. So I'm going to ask that person to unmute. To unmute on a telephone, it is *6.
That's for our attendee at 0818 is the last 4 digits of the phone number we see. There we go. There we go.
Hi. This is Teresa. Can you hear me?
It's very, very faint.
Faint? Better?
A little bit.
Okay, I just have one question that's general. I've listened to all of our neighbors speaking, and I believe everybody has valid concerns. Our neighborhood is way above third grade level. However, I agree with Susan that wording can be simplified. And I really think my main question is, why aren't we meeting in person? Why can't we all get together and talk about it? And when will you as the board decide that that's appropriate?
Thank you. Yeah, that question I think is going to be a meeting. So I'm going to leave that the board to next meeting. Tonight, just for the sake of your attorney fees, I don't want to spend time talking about anything about the walls. Thank you. I have Rachel up.
Rachel, I will ask you to unmute. Rachel?
Yes, can you hear me?
Yes.
Yeah.
Okay, perfect. Stop. So I just have a few concerns about this amendment, and I mean, I know it was withdrawn, but here my most concerns are: one, we have a yard that backs to Knox. So in my mind, and even when we were in the process of buying this house, our realtor was saying, yes, that back wall is HOA responsibility because it is on an easement and it is back to a street. One, I want to know if that still stands, because ultimately we bought this house in 2020 and there was already a gap in our party wall between our neighbors' yards and Knox. And at any given point, if you walk along the sidewalk on Knox after it rains, there is an immense amount of water that pools up and does not drain properly, therefore causing the dirt and the rock to erode away from the wall, making the wall more eroded and sliding away from our party walls. So one, I want to know how it's going to be clarified if and when that is our responsibility, because in my mind, that wall was not built properly. It should not be pulling away. There should not be water pulling up in the easement way along the sidewalk when it does rain, because it's very clear that that drain along Knox and Quinn is not draining properly. So that's my main concern with our wall. Two, I understand that, you know, there are assessment fees that get raised, and we have been grateful that we haven't had a raise in those fees in the past 3 years that we have lived here. But now it has gone up $10, and now there's this amendment pending. And I'm just wondering, okay, well, you're raising our fees $10 more per quarter. So for $10 more per house in this subdivision, if I'm correct, is 785 houses. That's an additional, $7,850. Well, in my mind, that's enough to fix perimeter walls. So one, I want to know where that money is being allocated, especially because I know that in the past year, trees have been cut down, grass has been removed so that it's more rock and xeriscaped. So if there's not as much landscape maintenance being brought in my area, why is my fee raising $10 in addition to amending this perimeter wall amendment? And when we reading the CCNRs, I do understand the difference between party wall, meaning between my neighbors on each side of me, whereas in the amendment talking about easements, that's where my gray area is and where I want clarification. So because my back wall is faced to Knox, where there's a street, there's a sidewalk, there's a drainage system, how am I responsible for 50% of that if that's the case and that's how you're amending and clarifying this?
Yeah, thank you.
And I want to also know too, yeah, I understand we have an HOA, but I want to know where all those fees are going, especially if you're cutting out more landscaping fees. You know, we don't have snow removal for you guys to be responsible for. And it has been very clear to me that if I walk one block north of me, that area is much more well maintained than the area that I live on in Greenfield Lakes. Like, I can't tell you, I've walked my dog every morning for the past 2 weeks, and there's been trash along the docks every day. It's the same trash for 2 weeks. But yet the grass has been mowed, grass hasn't been picked up. There's chunks of grass that my dog is attempting to eat because it's on the sidewalk. Like, this is where I'm concerned about, okay, well, you want to raise my fees and you want to make me responsible for a portion of this wall, but I don't see where this is benefiting me as a homeowner in your community.
Thank you, Rachel. Yeah, one of the hard things, this goes back to the builder issue. One of the hard things to disassociate from is the fact that the association and the builder are not one and the same. The association did not build the walls. It inherits the problems that are created by the builder, and you grapple with them. So to the extent that there's water pooling that on your lot and there's drainage, that would be a lot owner's responsibility to correct, to prevent the water from causing unnecessary erosion to the wall. And that's true even if the association assumes the full maintenance of the wall. If owners cause damage to association common area, owners are responsible for that. If you drive your car into an association tree and kill it, you would be responsible for the replacement of the tree. So if you're seeing those kind of issues on your lot, generally speaking, great idea to get those corrected so that we're not causing additional wear and tear on any of the facilities, your own home, your neighboring, the property interest that you share with your neighbors, the property interest you share with the homeowners association, whatever it may be. When we're talking about how much you're looking at assessments, I don't have an exact figure, but we are talking about hundreds of thousands of dollars necessary to assume the costs of full repair and replacement of walls. This is something for me, just as a homeowner myself and being involved in this industry, I have been shocked at how expensive walls are. They're just, I have a 9-foot wall behind my house, and I'm terrified that someday it's going to fall because they're expensive. And on the gap issue, that is something that maybe you want to get with Harmon with, because we have in all of these inspections, there have
Jonathan, I think you froze.
Jonathan, you froze.
He may have to call back in.
Art, do you want to answer Rachel's question about the assessment increase?
Yeah, I could do that. Rachel, the assessments went up by, I believe, $8 per quarter from 152 to $160 per quarter this year. The reason that we raised them is because we are in negotiations with our water supplier to renew our contract for the next 5 years. And the amount that he's asked for and the amount we're negotiating towards will require that that $2 a month or $6 a quarter over the next year. So that's what the addition went to, and not to any improvement in any other services, just in the additional cost of water. So far as your wall, the Knox walls are the #1 on our list that we really want to take care of first this year. And that's just, what our priority is. And secondly, you're asking about why there's water sitting behind your wall, between the wall and the street. Unfortunately, town of Gilbert does not have a storm drain system. All water is retained on the property away from the streets. And in fact, Gilbert streets drain into our property. And so that's just where we store it, is in that depression that's back there. So that you also see puddles in the parks, and various other places. So that's just the nature of trying to get rid of a lot of stormwater without having a pipe to put it in.
We have Jonathan back.
Yes, sorry about that. For some reason, I've been kicked off the internet here and it's not letting me reconnect. So I'll join on my phone until I figure that out.
It looks like our next person is AZ Kings. I will ask you to unmute.
Hi, that's just my screen name. Can you hear me?
Yes.
Okay. My name's Dan King. A couple of things I wanted to point out. First of all, and the comment was made, let's not insult our neighbors and say they can only read at a 3rd grade level. We want to keep this a little bit above that. I have a little bit of an issue with people saying, throwing out things like, well, it's a minority of people who have these walls. I like numbers. I'm a numbers guy. I'm an engineer. Give me the number of what that percentage actually is, and then we can have a conversation. Okay. Those are 2 comments. Another one, Jonathan, you started off this thing by saying it's just an infrastructure thing and the walls are aging, and you've acknowledged that they weren't built well. But in the amendment that you offered, you reserved the right to, one, get it fixed without talking to the quote party, which is not how party walls work. And then it said assess the homeowner the cost. If you deem that they were responsible for the wall failing, how are you going to do that? Because the age of the walls, right, and the fact they weren't built properly in the first place, if you try and go forward with 100% billing of the people, you are going to continue to get litigation, right? Because you're starting from behind. That's just a fact. So I think that we need to just go with, hey, it is a party wall. It's a 50-50 responsibility. And when we get down to it, we have to agree you, and I gotta be careful there. The homeowners association is the homeowners. It's not Focus. It's not you. It's not even the board. It is the homeowners. So we as homeowners have to agree how we're going to get the contractors in to fix that wall, like I did with my wall. My neighbor's tree took down a section of wall, or almost did, separated between us. He and I split the cost just because I wanted to be a good neighbor and not argue with him over it, and we fixed it. So I think, you know, the way you have it written, there are a couple other things. When you say you don't want to muddy the waters, you say you're going to assess the costs. I think you can only raise the assessments by so much a year. So what you really mean is you're going to find the homeowner to pay for the call. So I think there's some questions around that wording in the thing that you put out there. But my major point is, I don't really think, given the age of the walls and the lack of good construction, that you're going to be able to make a case for 100% on the homeowner without getting yourself into a lot more litigation.
Yeah, thank you. I don't want to give you the false impression that I think that the walls are poorly constructed. I recognize that people have interest about bringing claims about builders. These walls are 20 plus years old. I mean, they haven't fallen over yet. And so that's not my position, that the walls are poorly constructed. I'm not making that assertion. That's not my assertion to make. But yeah, I recognize the concern. We can go back to some of my prior comments about what we were trying to do with that provision about assessments. The association can, this would not be an increase of the regular assessment. That's capped. When we're talking about if you damage common area, the documents allow the association to assess you for the cost of the damage to the common area. That's a separate assessment. It's not a special assessment. It's not a regular assessment. But it is an assessment. It's secured by the assessment lien. It's not a monetary penalty. That's true for any damage to common area. But yeah, that's something we want to make sure we're cleaning up in a revised copy to make it clear that it's a cooperative effort. And that if we are including language like that, as I said, I'm not sure it's necessary, but if we are including language like that, that it's very clear that those are only kind of for those homeowners that aren't participating in the process, you know, okay, at some point this has to be imposed because it's a shared expense and the association can't assume the cost simply because you're not willing to write the check. I'm not trying to make that too blunt. And it's not my assertion that any of you read at a third grade level. We want to write things at a third grade level so that anyone who picks it up clearly understands what this document says. We want your kids to be able to understand it. The goal is not to insult. It's to tell you that we just want everyone to be as clear as possible. That's not what I did. I think I treated you all like lawyers.
I'm going to ask Cody to unmute.
Thank you. Cody, again, one other question. It's probably more of a question for the board or Focus. When it comes to getting bids for projects like this, what is the process for getting bids? And is one bid done? Is there multiple? And then is that information made public to the residents if they were interested in seeing that information?
Yeah, Harmon, do you want to speak to how you go through the bidding process for these kind of?
Yeah, sure.
issues?
Depending on whether it's a new contract like for landscaping or in this case it's for walls, we always get multiple bids. The board tells us how many. When we went out to landscaping, I think we got 5 or 7. When the last wall project we did, I think we had 4 or 5 different bids. So no, we never have ever gone with just even 1 or 2. And it's entirely up to the board. If it's public, I don't know that direct answer other than the contract the board does vote on becomes a record of the HOA, which is certainly available to homeowners. Correct, John? But
Exactly.
I don't know
Once-
about bids not voted on or not used.
Bids generally are not records of the association. We're not retaining bids in our corporate record. But the contract secured by the association would be something that we would disclose as part of a records request, generally speaking,
I would
outside
add
of
that,
any proprietary or something like that.
I would add that the board votes on and decides on which contractor or contract to use of the bids in an open meeting. So those meetings are always available for homeowners to attend to hear the deliberation of the board.
Perfect. That's
Can
very
I add to
helpful.
that real quick, Harmon? Cody, just to
I'm sorry?
I just wanted to add to Cody's question on the bids. And Cody, when we do take a vote on a contractor, we make sure that no board member or a management company member has any relationship with any of the contractors.
That makes sense.
Statutorily, that information would be have to be disclosed, right? It was a conflict of interest.
We have,
I think is Christian. Have we heard from you, Christian?
not yet.
Okay, at least want to hear from everyone one time before we
Sure.
talk to people the second time.
Asking you to unmute, Christian.
Yes, good evening, Jonathan. Thank you very much for coming and clarifying all this. I really appreciate it. Well, I had one quick question. I'm a real estate broker for now 20 years and deal with CC&Rs and HOAs all the time, with purchasing and selling homes, obviously. And my understanding is most HOAs that I ever run into, it's always 50-50 common and shared walls with the HOA. First of all, do you agree with that assessment, or is that incorrect? Number two is if we should change that to 100%, which is that the homeowners want to do that, the homeowners want to do that. What is stopping a homeowner like me then to screw up my life? Well, that's unfair. Now, I don't want to pay my wall against the golf course, so I want the HOA to pay 100% for that as well. Oh, by the way, while we're at it, why should I pay for my wall with my neighbor? Why? Because, you know, the other one was not 50-50, so why should I pay 50-50? Why shouldn't the HOA pay for that? Isn't that opening the HOA and the board for a tremendous amount of lawsuits, which means a tremendous amount of assessments and increase in HOA fees way beyond what we have here? Would you agree with that or disagree with that? And then, yeah, just for this quick comment to the board, thank you very much. I've had that house since 2004, and I don't think I've ever seen finances as good as this. And I don't remember seeing anywhere in the finances anything about 400,000 for legal fees. I've been following it as much as I can. Maybe I missed it. Maybe the board can clarify that, but I did not see that. So anyway, thank you, Jonathan, again. Thanks for coming.
No problem. Thank you. Yeah, you're right. That's why we call it the common law principle, the general rules of party walls. Most party wall issues are shared 50-50. The vast majority of CC&Rs would do that. Not all of them. Some CC&Rs do have homeowners associations that assume full responsibility. Some have owners assume full responsibility. So you can see, so those variants exist, but yeah, the general rule of party wall, if we had no CC&Rs for your association, the default for this would be that the owner and the association would share the cost 50-50. The change to 100%. Yeah, I tend to think that if we went the other direction with this amendment and made it so that the association had to assume 100% of the expense of maintenance of the party walls, and we adopted this interpretation of parcel and perimeter wall and kind of pieced that all together, that would also be susceptible to challenge. It may be susceptible to more challenge. You know, one of the things we have to grapple with CC&R amendments is a new Supreme Court case that we reference as the Callaway case, that identifies that we can't really use our amendment power to, we use amendments to clarify and to fill in gaps. And so that's what we're trying to do. We're trying to clarify and fill in gaps. We're not trying to change the CC&Rs. I tend to think that the argument would be better that if against the association, against the validity of the amendment, if we went to a 100% association obligation, that claim would be liable to challenge from a homeowner disgruntled by the increase in the assessments, or you name it, and could be voided as well. But I tend to think we would be safer adopting the 10.1 interpretation of party walls.
Jonathan, can I jump in for a second?
Sure.
Thank you. There's been this question or misinterpretation on the financials of the legal fees, and Jonathan said, you know, the financials are available, and they certainly are. But I'm sitting here in front of my computer. I wasn't going to give a number, but I will give a number. Since we started keeping your books in April of 2020 till today in the books, we have the HOA has spent a total on legal fees of $51,429.56. And I'd be glad to share that with any homeowner who wants to come into our office on a document request for all that detail of our P&L and costs. So I just wanted to clarify that.
Thanks, Norman. That's great. If you guys have $400,000 in the bank, though, and want to throw it at carpentry, we'll make it possible. Just kidding.
Okay, so it looks like we have.
I have iPad and Mackenzie that are new.
Yep.
I'm not trying to push Dan and Bill off, but I want to make sure we get new comments first.
Okay, I'm going to ask whoever is iPad to unmute. iPad, your name is listed as iPad. I've asked you to unmute. You may unmute yourself.
We want to move on to Mackenzie while we wait.
Yep, I will ask Mackenzie to unmute.
Yeah, sure. I don't know if you guys are taking these questions during this session. I don't know if it's just strictly about the walls, but we were curious about paint colors, and I know quite a few of us on our block have received notices and that we've responded back to you guys and trying to repeal like your disagreement with the way we painted our homes. We haven't heard back from you guys, so I want to just here to say I would like to hear if we're okay, we're in the clear. We haven't received a response. I think it's been over a month now.
Hi, Jonathan, I'll answer that real fast. Mackenzie, those are reviewed in executive session at the next board meeting. That was advised to you in the email when I received your appeal, and those will be discussed in the executive session. And you can attend, and that's the board that reviews them.
Awesome. And then I guess one other suggestion, perhaps we could go to in-person meetings now. That might be a little more interactive.
That's on the agenda for the board for next meeting, but this meeting is just regarding the walls.
Okay, all right.
Okay, thank you. Okay, sorry, Jonathan, go for it. Oh, I lost Jonathan. Hold on, he's coming back in. Unmuting you, Jonathan.
All right, sorry about that. I'm not having the best luck with staying on connection here, although it's showing my internet is strong.
It doesn't look like the person with the iPad has their hand raised anymore, so I'm going to ask Bill to unmute.
Yeah, thank you, Jonathan. Yeah, great information. Besides the party walls, we also have now, I would consider individual walls. This would be the properties lining the golf course, the properties on the eastern side of the HOA, and specifically on the Freeway 202 border. Starting with the freeway, I assume, Art, you may be able to answer this. Did they tear down our wall and rebuild that higher wall? And would that make them 100% liable for that wall maintenance at all? Would we have any ownership at that at all? Which I hope we don't. As far as to the east perimeter wall, now that new associations have been built up to our wall, would they be privy to also be included as a party wall participant if the wall needs maintenance because they're sharing our wall with us? Would they have to reimburse us because we did put that wall up? And then for the golf course, I've been hearing things about water from the golf course is spraying on the iron rod fence, deteriorating that. I heard that the golf course did get letters from the state in cutting back water usage. So I do not know about talking to the golf course owner about that situation, that because of the fencing out there, the water was helping deteriorate it.
Jonathan, okay.
Sorry, I was still muted there. Yeah, you know, I can't speak to specifically causation and deterioration of the walls. I think for tonight's purposes, we need to focus on the actual amendment. You know, as it comes to specific areas of maintenance, that's something that the board can address at a separate board meeting, unless you have information you'd like to address tonight. But we're at an hour and a half into our meeting here, so I don't want to overcharge you guys for time.
We have Eric Barrett. I will ask to unmute.
Yeah, my question is, looking at plat reviews, it seems like these perimeter walls are built on a PUE, which either might be a utility or owned by the town of Queen Creek, or it might be a parcel or tract owned by the HOA. So it seems like these walls aren't even on the lots. These walls are actually on HOA common property. So I would think that would mean the walls really aren't even ours. But my second thing would be, with maintenance, are you including stucco and paint, or are you guys just talking about replacing walls, wanting to share the responsibility 50-50?
It's both. You know, when it comes to major reconstruction, that's one thing, but you know, generally speaking, yeah, wall maintenance is stucco and patching, and usually those the general rules of party wall tell us just you take care of the side that faces your lot, and the association takes care of the side facing its lot, sort of thing.
Yeah, and then you know, these perimeter walls they're constructed a lot different than your typical party wall. So the cost of a perimeter wall is going to be extremely higher than your typical block wall that's, you know, stacked with mortar and you know, not reinforced with steel. And so you're putting a lot of burden on the people who live with the perimeter walls. And I just don't think that's right.
Sorry, I pushed the wrong button there. The thanks, Eric. Yeah, again, the association position is this isn't adding any additional burden to homeowners. This is preserving the current burden that homeowners have. I have, I'm not sure how I pronounce that name.
Oh, it's just Jay.
Okay.
It's all right, Jonathan.
That's all right.
First off, this has probably been a productive meeting. I think it is. I think one of the reasons that we're all really here, because we've heard a lot of stuff tonight, is I think we still don't have the clear definition of common areas. I know it's been kind of thrown around historically, common walls versus party walls. And then, of course, perimeter just came up again. I think we all, through common sense, understand what a perimeter wall is by its definition. But, you know, it was stated earlier that historically it's always been a 50-50 split between the homeowner and the association. And I believe one of the first gentlemen that got on it asked about this as well. And I've heard there's been lots of accusations of wall maintenance requests that have gone unattended or repaired. And so my question is, does the HOA historically have those documents over the past couple of decades where a request has been made and granted and where that cost has been shared? Because if it's always been that way historically, well, then I don't really have any beef here because that's just what it's always been. So, I'm not here to change that. But if it hasn't been, if there are no examples, and then that's kind of what we're questioning. And again, can we define common areas? I think a lot of times it's been asked tonight and the answer's been kind of deflected. So we still don't have a clear answer to that. As far as the cul-de-sac walls, I think that was asked earlier, and I think the response, so this is either yes, no. I think the response was 50-50, which I don't live on a cul-de-sac, but I can definitely understand how that can be unreasonable given the conditions of the walls over the years. With regard to party walls, I do know that the wall that I share with my next door neighbor is 50-50. I've asked for help before in the past and was told, deal with your neighbor. It's like, okay, acceptable. But having a wall that backs up to Warner, where, I consider that a common wall or perimeter wall, and that's not clearly stated in 10.1. I think in 10.2, the damage due to accident, I couldn't see why anyone would have an issue with that. I know you brought that up a few times as an example. I don't think anyone's questioning that. If I damage the wall, someone at my house damages the wall, that should 100% be on me. But if a tree, a car, something were to damage the wall from the main road, don't think that should be on me, even 50-50. So I think we all want to know that definitive answer of who is that on. And that's really all I have.
Sure. Yeah, I'm not sure I'm familiar with this cul-de-sac question. I guess I'm going to answer it generally speaking. If a wall is entirely located on the common area, it's indisputable that that's the association's responsibility. If a wall is entirely located on your lot, that would be your responsibility. There's no interpretation of the CCNRs that would be something that's shared. When we go back to this argument of this idea of a perimeter wall, I want you to remember that what we're talking about is not a provision of the CCNRs that says the association maintains perimeter walls. It's a provision that says the association and the owners have joint easements to make installations, replacements, maintenance, and repair of perimeter walls. But it doesn't. Both the association and the owners are both equally contemplated in that provision. It does not say the association maintains perimeter walls. It's really more of this like, okay, you've got to piece together that with the parcels with that even come up with an argument. And as it relates to walls that are shared with a non-common area, the documents, that would be a wall that's entirely located on your lot. And so if you have a wall that's constructed next to non-association property, it's likely that if we did a survey that's entirely on your lot, or if it is shared with that neighboring property owner, it would be the general rules of party walls would apply with regard to your right to seek contribution from the person who shares that wall with you, be it the town of Gilbert or whomever. And then as it relates to a vehicle crash, if there is an accident under the section 10.1, if there's an accident to the wall that has no fault of anyone, then the general rules of party wall would apply, which means that the parties would share that expense 50-50. When we have in homeowners associations, or that's to think of a car crashing through the wall, generally what we will do is try to subrogate the claim that we have. That's something you might be able to tender through insurance. Then the insurance carriers or whomever, the association and the owner or whoever is damaged by that would make a claim against the driver's policy to try to recover those damages. But absent contribution from insurance, the general rules of party walls would say you would share that 50-50. Hopefully I captured everything there.
So it looks like John Shee, I'm going to ask you to unmute.
Good evening. I've just got one question, and that is, I walked down the wall on Knox was referenced earlier, and I noticed that there are large trees on the inside of the walls. which would be on the homeowner's property. So given that those walls are cracked and most likely those large tree roots are the cause of the wall moving, is the HOA still going to pay half of the expense of repair?
You mean if like a tree, a common area tree is causing the damage?
No, a tree that's inside on the owner's property fully is causing the wall to crack or
Sure.
move. Is the HOA still going to pay half of it, or is the cause of the original cause is from the owner's property? Is the owner going to pay 100% of the repairs?
It's possible that the owner would be responsible. We would have to engage an engineer to determine what the cause of the wall's failure was. And we look to the CCNR provisions in section 10 in section 10 that talk about negligence. And so you have to establish more information. It's not that simple to say if the damage originates on your lot, you're responsible. We have to establish some sort of willful or negligent act to establish that. It's possible, but not always.
Yeah, but the question is, it's not willful, it's just a tree growing. Is that considered willful?
Not always. Not always. Yeah. It could be, but it's not always.
Well, see,
May I make a comment?
That's the problem. When you say it could be, but not always, then you're involving attorneys and litigation.
Yeah, unfortunately, my job exists. There's no way I can get around it. There are going to be disputes. All we can do is address the vast majority. If you build a tree, if you put your tree right against the wall and you let that thing grow and push it over, that's probably negligent. If you put a tree in your lawn that grows naturally and the roots just grow as natural, and then we have no arborists that say, hey, as a natural course of maintenance, you would cut off these roots, well, it may not be negligent. So there's more information that's necessary. Unfortunately, that's one of those case-by-case basis, but could be. Yeah, if I affix something to my back wall, or I decide that I'm going to build an entertainment area with a water feature that causes erosion to the wall, that might be negligent. Might not be. But we have to look at the facts. It's case by case.
May I make a comment, Jonathan?
Yeah.
As a board member, this is one of the areas where we wrestle with it, because if we come across this, which we have to weigh how much is it going to cost to just pay for half that wall versus how much is it going to cost to hire a professional to determine it and then go to court. And sometimes, you know what, it's just easier to just pay the half of the wall and move forward.
Sure.
And it's just a judgment call we have to make.
Exactly.
Okay,
I think we've got our last two comments here. I have Dan King, I believe.
Yeah. Dan, asking you to unmute.
Okay. Just for a quick clarification, because when Jonathan was responding to me earlier, at least from my perspective, he kind of waffled back and forth between common area and shared wall. He said if I did damage to a common area, I'd be responsible, as if that's what we were talking about, if they decided I had done some damage to the shared wall. And I just wanted some clarification about, are we assuming that that wall is the common area, and that's the basis for saying if you're deemed to have damaged it, then I can bill you 100%?
No, the CCNRs contemplate damage to common area, that if you've damaged common area, you're responsible for restoring. Right. And then you've got elements in the party wall that say if you as a party wall owner damage the wall, you'd be responsible for the full extent of the repair. Does that clarify that for you, or is there another element there?
Yeah, I think it kind of goes to the comments that have been going back and forth here for a little while. You're going to get into a bind because with all due respect, you did call into question the quality of the walls in some of your opening comments, and they're old which you acknowledge, and the infrastructure is failing. So at some point, how do you determine whether it's just infrastructure failing, or you're going to hire people? And again, to our board member says, why do we want to do that? So why do we put ourselves in the position where we're going to have to argue that with homeowners? Because like you said, you want to clarify this, make it simple, and get away from those things that cause us to have to make decisions about, am I going to bring a lawyer in? Am I going to adjudicate that? And only do that kind of thing when the homeowner refuses to participate in the 50-50. My comments. Thanks.
Yeah, and just to clarify, my comment is I'm not going to weigh in on the quality of the builder's infrastructure. You have 30-year-old walls. The lifespan of a wall is not perpetual. You have a reserve study that tells you that there are going to be replacements necessary to a wall. Not all of them. I think it's hard to say that the quality of the builder's work should be something that we'd be very frustrated about, because they have withstood the lifespan of the wall in more cases than not. But I'm not going to opine on that because I'm not an engineer. And so what does happen when we look into these things is we hire experts to inspect. That's what the association has done. That's why you have a report that prioritizes wall repairs. And you work off of a reserve study in that report, the engineering reports. All right, Christian, are you ready for our last comment of the night? Hanging in there.
Yes, hi, thank you. Just a very quick thing. Just a clarification for you and the board question. As far as I understand, I think a lot of people are confused with perimeter walls, shared walls, party walls, blah, blah. There's so many words thrown out in there. But if I can just recap, as far as my understanding it is, and tell me if I'm wrong. Number one is our so-called perimeter walls that could be possibly shared with SRP or the city of Gilbert, that we really don't have any, because everything is on the HOA land. So the only sharing we're doing is a party wall between the owner and the HOA, if that is correct or not. And even if we did have that, it wouldn't really even, in that case, that wall would be 100% the owner's responsibility and not SRP and stuff like that. If it's from their property, the plats would have been laid out that way in the first place. And then, so in other words, is all the walls are shared walls. They're either going to be shared with your neighbor, they're either going to be shared with the HOA, or they're going to be shared with the golf course. And the only one where you have to pay 100% is on the golf course, because apparently that's within the golf course CCNRs. And all the other ones should be shared. Am I putting this kind of in a general format of what it looks like in our community?
Right, that's kind of historically how it's operated, and that reminds me of another question that was asked earlier about what do we mean by historically? Well, there aren't a ton of historical representations of what the associations had to do. The walls haven't failed. They're, for the most part, no one's had this problem. As you look forward over the next 50 years, you will see more, because that's just the reality of how things work. Hopefully not too many, but you've got to look at the lifespan of cinder block walls. So, but yeah, that's generally the position. I can't speak to I'm not going to tell you that anyone's position tonight is wrong. I'm going to tell you that I can tell you what the association's position is. I recognize that there are alternative arguments, but all I can tell you is, from my experience, this is how this generally works out. All right. Any last comments from the board?
Well, the board appreciates all the comments and questions from all the homeowners. It sounds like we're all pretty much on the same page. I think it was a very productive meeting.
Absolutely. I appreciate everyone's comments. Very well thought out. This is a great use of time. I appreciate it. And then you come up with any supplemental questions, you can direct them to the board and management, and we'll address them in due course.
Thanks, Jonathan. Thanks, everyone.
Thank you. Thank you, everyone, for joining.
Thank you, Jonathan.
Have a great evening.
Thank you.
Thank you, Brooke.
Thank you.
You can end the meeting, Brooke?
Yeah, I was just holding off for a second.
Okay. All right, that's it. Everybody else is bored.
Yeah, that's what I was trying to do.
Yeah, I know. Lock the meeting.
But
But we
Ron,
don't have a quorum, so that's good because Art's gone.
Ron's gone too.
Yeah, Ron's gone too. But then
And
we'd have a
Todd.
quorum. We don't have a meeting.
Yeah.
That
Todd's
went
gone.
way better than I expected.
I agree.
I don't know what you think about Kevin and Darius. So that's the comments.
Darius is muted.
I'm asking him to unmute. And I gotta,
There
I'll
you go.
change the securities.
Okay.
There we go.
Should I text Ron?
Yeah, you can.
Oh, yeah, we don't want to have a quorum though.
Yeah.
Do you want to turn off the recording or?
Yeah, do that too.